bring you an update to a story we've been following for the last several months about a high school student who was suspended from her school for refusing to wear her student identification card around her neck. 15-year-old Andrea Hernandez said she objected to wearing the ID implanted with a radio frequency identification chip on religious grounds, calling it, quote, the mark of the beast. The school agreed to take the microchip out of the ID card, but would still require her to wear the badge. And she refused and sued the school. Well, yesterday, a judge sided with the school. Now, she lost her battle, and the ruling could teach us much more on the war being fought in this country against breaches on privacy and civil liberties. Let's speak now with John Whitehead, who represented Hernandez in the case and is a constitutional attorney for the Rutherford Institute. Hey there, John. So talk to me. These RFID tags, they're a way for the school to try to keep attendance up, to say, you know, if you're not in class, we still know where you are. The funding they receive from the state is directly tied to attendance. So give us the legal reasons here first that your client took issue with this.
Well, first of all, she had a religious objection. She's an evangelical Christian. They feel this is the mark of the beast of the Antichrist, and to wear it would be worshiping a false god, essentially. It's a complicated view, but as the Supreme Court has held, the views don't have to be totally rational for everybody to believe it. They have to be sincere. The judge here actually said, though, in his decision yesterday, that she did this for so-called secular concerns, not religious concerns. Well, the Supreme Court has been very clear that courts cannot second-guess people's religious views. They can go to whether or not they're sincere or not. And obviously here she's been very, very sincere about her beliefs. And the school, when we got in the case, it caused quite an uproar, press releases, those kind of things. So they said, hey, here's what we'll do. If you'll wear the badge endorsing the program, we will take the chip out and you can stay in school. And she refused to do that. She says, I cannot endorse a program that violates my religious beliefs. This is forced speech. The Supreme Court's been very clear that students can't be forced to do these kind of things. And these cases go back until the 1940s. Also, there's a very important equal protection claim here, is because she wouldn't wear the badge and the chip. She couldn't vote for the homecoming king or queen. She's limited in library services, extracurricular activities, and she's been placed in a segregated lunch line. Wow. Again, I thought we did away with the word segregated in our schools today, but it still exists. But I think on appeal, we're appealing to the Fifth Circuit Court of Appeals. We've got a good case. These cases usually go through the courts. I think that the Supreme Court might even want to take a look at this one. And the key issue in the case is whether or not, if people have concerns about their privacy, about being tracked everywhere, can they opt out of these programs? And that's all she's asking here.
So I want to take apart a little bit about, you know, what happened here and take a look really quick at the ruling itself. Judge Orlando Garcia ruled that, quote, the accommodation offered by the district is not only reasonable, it removes plaintiff's religious objection from legal scrutiny altogether. So basically, they're saying removing the RFID chip, Andrea Hernandez can no longer make a religious argument. So that's what the judge said. So let me get your response.
He can't say that, though. Like I said, the Supreme Court's been very clear that courts cannot second-guess people's religious views. If it's sincere, it's a religious view that's protected by the Constitution. And I think that's a really good issue on appeal. So I think we've got really good issues on appeal. He didn't even really carefully look at the equal protection argument, was that she's being treated like a second-class citizen in our schools. So I've been practicing in this area for many, many years, and cases that we've won at the Supreme Court, we've lost every place else. So this is going to take more carefully refined judges at the Fifth Circuit. But I think in the Fifth Circuit Court of Appeals, we got a much better case.
Yeah, that's what I was going to ask. And we do have quite a few viewers who have been really interested in this case, have been following it. You said that you're going to appeal it. So how long does this process work? How long does it take?
It takes a while, but I think the key of this case is these chips are going to spread around the country. The large corporations are making a lot of money from them. So they're going to be influencing school districts to use them. In fact, the palm reading devices are already in schools as well, where kids have to have their palms read before they can even eat lunch. These are money-making schemes. So I think the issue in this case is, if you have an objection, either constitutional or religious or otherwise, can you just use a regular ID, which 99% of students in the United States use? Why can't she do that? Why is she restricted? Well, obviously here the school wants the money.
Yeah, it's interesting. I mean, but I've got to say, John, a lot of critics are looking at this case and saying, you know what, some schools have uniforms. Most jobs have ID cards that you need to keep with you.
Sure.
Don't students, especially those under 18, invariably give up lots of rights, you know, when they step on school property?
Not really. Their rights are more limited because they're not adults, but she's willing to use an ID. Again, like every school in the country, 99% of the schools in the country have ID cards. She just wants a regular ID card. This violates her rights. And the question is, in America, in a state school, are you forced to become a second-class citizen because you won't use an RFID chip? Why can't she use a card like every other kid in the country uses? And again, this is not for safety. The school's been very clear. They get money from the state. And it's not classroom attendance, by the way. It's attendance in the school. You can be in the bathroom, outside smoking a cigarette, doing a dance out on the football field. It's not classroom attendance they're calculating here. So it's a money-making scheme. That's what it is. But the question here is her right to opt out of this program constitutionally protected? If not, folks, it's over. You will have no privacy.
Well, that's what I wanted to ask you. I mean, you lost this round, but what are you hoping the discussion becomes? What are the bigger implications of this case here?
The bigger implication of this case is that if you object to a program like this on religious grounds or constitutional grounds, can you opt out of the program, just have a regular ID card, and still be treated like a citizen, an equal citizen? Here she was treated unequally. She's in a segregated lunch line. She's watched like she's a criminal. Is that the way we're going to treat our kids in school if they stand up for their principles?
It's a really important question, one we'll keep our eye on. John Whitehead, who represented Hernandez in this case, he's also a constitutional attorney for the Rutherford Institute.